Welcome to this explainer. Today, we're diving deep into the intricate mechanics of third-party beneficiary contracts. Now, I know contract law can sometimes feel like this impenetrable maze of legalese, but we're going to use real-world case briefs to bring the black-letter law to life. We're going to look at the actual disputes that shaped the rules, ask the tough questions, and really dig into the rationale behind the answers. So, let's jump right in. To master this, here's our roadmap. We'll start with the core contract framework, move into creditor versus donee beneficiaries, then vesting or locking in rights. After that, enforcement, meaning who can actually sue, and finally, defenses and contract equities. Okay, Section 1, the core contract framework. To analyze literally any third-party situation, you have to know exactly who is involved at the very moment of contract formation. Professor Dodge provides a brilliant two-step analysis for this. Step 1 is labeling, figuring out the beneficiary's exact status. Step 2 is vesting, determining if their rights have officially locked in. And, you absolutely cannot skip Step 1 and just jump to Step 2. There's a very strict dividing line in that first labeling step. An intended beneficiary is someone specifically contemplated by the original parties at formation, and because of that, they acquire actual legal rights. On the flip side, an incidental beneficiary is just someone who happens to benefit. The black-letter law here is crystal clear. Incidental beneficiaries possess absolutely zero rights. If you label someone as incidental, well, your legal analysis ends right there. Moving on to Section 2, creditor versus donee beneficiaries. Once we know someone is an intended beneficiary, our labeling step requires us to figure out exactly what kind they are. The first is a donee beneficiary. This is a third party who gets the contract performance as a pure gift or gratuity from the promisee. Because they're just receiving a gift, it fundamentally limits who they can eventually hold responsible if things go wrong. Conversely, we have the creditor beneficiary. This is a third party to whom the promisee owes a pre-existing legal debt. The promisee then extracts a performance from the promisor specifically to pay off that debt. This pre-existing legal obligation gives the creditor a much stronger enforcement position, which we're going to see shortly when we talk about who can sue whom. All right, Section 3, vesting, locking in rights. Let's move to Step 2 of our framework and look at vesting. Vesting is essentially the ticking clock of contract modification. It's the ultimate point of no return, the precise historical moment a third party's rights become completely fixed. Before vesting happens, the original parties can freely alter, amend, or even completely cancel the deal without asking the third party. But after vesting, those rights are locked in stone. The original parties are legally barred from unilaterally reducing them. To really get why this matters, let's look at the human drama in the Detroit bank case. It perfectly maps out this timeline. Back in 1964, the founders of a company enacted a resolution to pay a widow's stipend to their surviving spouses. Fast forward to February 1971, the company is facing financial trouble, so the founders rescind that exact resolution. Months later, in October 1971, one of those founders dies, leaving behind his widow, Roxanne Scott. She tries to claim the stipend, and boom, we have a major legal dispute over vesting. Which brings us to a fascinating question at the heart of this dispute. Roxanne actually knew about the 1964 resolution shortly after it was made, but she testified that she made no plans based on it and, frankly, just forgot the whole thing. So, is merely knowing about a future benefit enough to vest it? Is it enough to lock it in and stop the original parties from changing their minds to save their own company? The court answered with a resounding no. Just knowing is not enough. This case established a critical piece of black-letter law. Contracting parties can freely rescind before vesting. While the law might presume acceptance to protect an infant or minor, that presumption does not extend to competent adults. For an adult's rights to vest, they have to actively manifest dissent, detrimentally rely on the promise, or file a lawsuit. Roxanne did none of those things before 1971, so her unvested rights were entirely extinguished. Let's move to Section 4, enforcement. Who can sue? We need to look at exactly what happens when a contract is breached. Who holds the power to drag someone into court? First, imagine this scenario from the Druin case. A husband and wife make a contract during a divorce where the husband promises to leave 30% of his estate to their son. Years later, the mother passes away. The father then rewrites his will, stripping the son's inheritance down to a restrictive life estate and throws in a vicious in terrorem clause, meaning if the son sues to challenge the new will, he gets absolutely zero. The son is paralyzed. So the question is, can the deceased mother's estate step in and sue the father's estate for breach of contract instead?
The Supreme Court of New Jersey said absolutely yes. As Druin established, a promisee has a sufficient interest to entitle them to sue. Think about it. The mother bought and paid for that promise. Her estate had standing to sue in equity, ensuring the promisor father couldn't just use a coercive clause to escape the duties he bargained for.
Now let's look at another enforcement issue, this time for a creditor beneficiary. What if a new company promises to pay off an old lumber company's pre-existing debts? If you're the creditor owed that money, do you have to pick just one company to sue, an election of remedies, or can you go after both of them at the exact same time? The Erickson case gives us the rationale here, and it is a massive win for creditors. The court totally destroyed the old, outdated theory of implied novation. The black-letter law now dictates that a creditor beneficiary has concurrent, cumulative rights against both the original promisee and the new promisor. No election of remedies is required. You can secure valid judgments against both parties simultaneously. But there is a catch, of course. Your recovery is strictly limited to a single satisfaction, meaning you only ever get paid once. So here is your ultimate cheat sheet for enforcement. Based on that labeling step we did way back at the beginning, notice how a donee beneficiary can only sue the promisor. Why? Because the promisee just promised them a gift, and you generally can't sue someone for failing to give you a gift. But a creditor beneficiary, they get to hold both the promisor and the promisee accountable until that pre-existing debt is fully paid. All right, Section 5, Defenses and Contract Equities. For our final section, we're flipping the script. We've talked about enforcing rights, but let's step into the shoes of the promisor to see how they can defend themselves when a third party unexpectedly comes knocking. The foundational concept here is subject to equities. Because third-party rights are entirely derivative, meaning they originate from a contract between two other people, they are inherently vulnerable. The beneficiary essentially inherits all of the contract's systemic liabilities and flaws. Whatever defenses the promisor had against the promisee, well, they generally have those exact same defenses against the beneficiary too. Let's test this with a question from the Ravel case. Let's say I promise to pay your supplier $670 to settle a dispute we're having, but in exchange, you agree to fix the terrible installation job you did in my grocery store. What happens if you completely fail to fix the store? Do I still legally owe your third-party supplier that $670? In cases like Revel and Rouse, the courts firmly answered no. Beneficiaries do not get a free pass. They cannot act as insulated shields. The black-letter law dictates that a material breach or a total failure of performance by the promisee is a completely valid defense against the third party. Furthermore, as we saw in the Rouse case, if the promisee committed fraud during the sale, the promisor can use that fraud as a defense to entirely avoid paying the assignee or beneficiary. However, Rouse also highlights a really fascinating exception you need to be aware of. While a general fraud defense survives, if you contractually agree to pay a very specific, fixed monetary debt, in the Rouse case, it was a fixed $850 for a heating plant, you generally cannot escape that specific promise by digging up old performance or installation flaws between the seller and the creditor. By naming a specific debt amount, you've essentially isolated that obligation. As we wrap up this explainer, having seen how these black-letter laws operate in real-world cases, I want to leave you with a final provocative thought. Given how fragile unvested rights can be and how completely vulnerable a beneficiary is to the defenses and breaches of others, how can any commercial entity confidently build a business model on contracts made by people they don't even control? It's a massive risk assessment that every business has to make. Thank you so much for joining me on this deep dive into third-party beneficiaries.